the EU and UN bureaucracy is quite a success. So please, can you say a few words on these projects and how do you see the future cooperation among your colleagues and with the Tribunal?
Hvala, gospodine Bramec. Prije svega...
Mr. Brammertz, allow me first of all to greet everyone present here. I'm pleased to be able to discuss with you the issue that has been on our shoulders for the past 20 years in the region. But before I respond to your question, I would like to make one point. I wouldn't agree with the term International Criminal Court or local jurisdictions. I would first of all say that these are national jurisdictions, and we can't talk about the cooperation with the ICTY and OTP because, if I'm not mistaken, Croatia was one of the countries which provided the initiative for the ICTY to be set up. Though this is something that my minister and professor will discuss this much better than me. Now, why am I pointing out that cooperation is important? Because cooperation between the ICTY and the OTP on the one hand and national prosecutors and courts should be by far stronger, consistent and standing, not only at this stage when we have the closing strategy, when the issue of the placement of archives is being raised. What I want to say is that the projects that are already in place are so belatedly. Back in 2004, with the assistance of the OSCE, because at the time we still needed OSCE to help us establish liaisons between Serbian, Croatian and Bosnian prosecutors, we had the first meeting, which was held at Palić. And to everyone's amazement, it didn't take us long to agree on certain basic questions concerning cooperation among prosecutors' offices in the region, which would enable us to address certain war crimes issues to a much higher level and yield certain results. What followed next were meetings at Brijuni, which have been held routinely or every year since 2005, and which have proved to be very constructive, fruitful, and bearing specific results. We were discussing scholarly issues yesterday, and I'm not at all for that. I am all for practice. I am all for specific conclusions. What we first realized was that it was far easier for us than it was for courts which have to go about collecting formal evidence. We realized that we needed information and daily exchanges of information in order for us to be able to bring certain cases to conclusion or to open up certain cases that have been left unopened for a number of years. My colleagues Vukcevic and Barashin and I have agreed that we should sign an agreement on cooperation based on which we have been exercising daily communication among all the prosecutors' offices in the region, not just the three of us, therefore, but all of those working as prosecutors in the region. Based on the agreement, we have had daily contacts and discussions. The police worked as per our orders in Serbia, Croatia, Bosnia-Herzegovina. And it was on this basis, and I can speak certainly for myself, and I'm sure for my colleagues from Bosnia and Serbia, we opened up dozens of war crimes cases which could not have been opened by then, since we lacked evidence. But that was not all, of course. We in Croatia were faced with great difficulty that the President of the Supreme Court touched upon. In the 90s, we went far too wide and broadly in trying to indict war crimes, since the criteria and the framework we had was not fully compatible with the law. I have to admit that. It is also a fact that at the time the prosecutors issued indictments and courts tried cases in absentia, which was not a very good decision. This was something that was referred to by the President of the Supreme Court here as well. While admitting to our mistakes, we tried to review these war crimes trials, and from 3,900 indicted persons, we reduced the cases to the number of 1,100 persons who were either at the stage of being investigated, indicted, accused, or tried. Another matter which was important for trials in absentia was that we amended the penal code so that to avoid having the prosecutor becoming an NGO and having to propose that certain cases be retried. What happened was that unfortunately, those who had been convicted out of such cases did not themselves apply for review of trials. There was one other matter that we didn't know how to deal with and couldn't have dealt with until the respective countries signed all the requisite treaties, until the constitutions in the respective countries were amended. And this is something that still remains open, especially when it comes to extradition laws. We tried to approach the matter in a rather peculiar manner, which some would say from the legal profession or from law universities was not that ordinary. However, we decided that our cases in Croatia, Serbia and Bosnia should constitute a source of information for our fellow prosecutors in our neighboring countries. On the basis of this, the total of 24 cases were handed over to Serbia, covering, I think, 42 persons. And, of course, in application of the law on criminal procedure in Serbia, etc., etc., final judgments were rendered by Serbian courts in these cases. At any rate, our cooperation in the region is actually so advanced now that borders do not constitute a wall to us, to the prosecutors. They cannot constitute an excuse for obstructing cases, and of course it enables us to obtain evidence. The fact of the matter is that the prosecutor's office during the 90s all the way through to, 2000 or even to this day, has been consistently collecting evidence and facts in the region, examining and interviewing witnesses and collecting material which is now here in The Hague. And I think it has some 9,000 files. So the flow of information was in one direction only, from the region to The Hague. In the past 5 or 6 years, thanks to the very efficient cooperation between the OTP and the prosecutors in the region, and based on the agreement we signed with the ICTY OTP, the local prosecutors were given access to the ICTY archives. It was in this way that we started obtaining documentation, evidence, and papers which enabled us to initiate legal proceedings that were at a standstill and could not proceed from there due to a lack of supporting material. Of course, the project is a provisional solution only because in relation to the closing strategy, we need to provide ourselves with mechanisms that would enable us to already today and not in 5 years' time to use the archives, and I'm primarily thinking about prosecutors and judges insofar as the law will will allow it for pending cases and for the cases to come, and only at a later stage should the archives be used by scholars who will be resorting to them in order to produce their scholarly papers and assessments of the war which transpired in the region. For this reason, as pointed out by Mr. Brammertz 2 years ago, we agreed at our meeting in Briuni that we should embark on a project which was supported by the European Commission. Mr. De Geer is here among us, and he recognized the initiative right away and supported it. whereby young prosecutors of the region should visit the ICTY OTP, where some of them would be actively collecting material needed by us for new cases, and others to take part in the work of the prosecutorial teams so that they may be one day able to, even more efficiently than us, take up the role of prosecutors in the region. And the project is really going on well. And I told Mr. Vukcevic yesterday that thanks to our last year's work with the liaison officer of the Croatian prosecutor's office, we were able to open up 2 more war crimes cases, which is a very important matter. And this begs the following question. Is this project necessary? Yes, it needs to continue, but it needs to continue in the following way. The transitional team of the OTP should, regardless of the closing strategy and regardless of whether this will be within the OTP, within the registry, or within the chambers of the ICTY, it doesn't matter, that the team of people working currently in The Hague, and I'm referring to the liaison prosecutors, they should be given support and their searches of the files should be facilitated. On the other hand, we are faced with a situation that I have to be critical of, and that is that we have the liaison prosecutors here, but they do not have access to all the files, and they need that access today. I think they will need it far less in 10 years' time. This criticism is, of course, outweighed by the advantages of the project, which is definitely helpful. At least this is the assessment by Croatia or by the Croatian prosecutor's office. However, prosecutors should be facilitated in their efforts to open up new cases, and this will be a justification of the effort and resources placed into this by the OTP. Another project, and I'm sorry for taking up this time, which was launched 2 years ago, is that we were faced with the fact, and primarily I'm speaking of Croatia, that there were many criminal proceedings against perpetrators known and unknown. We had many statements and pieces of evidence that has not been systematically compiled. It also transpired in our discussions with our colleagues from the region that similar or even better information that would be helpful for our cases were in their possession too. So we decided to create a database which would encompass all the information compiled by the Croatian prosecutor's office, which by conducting very simple searches, will allow prosecutors from the region to gain access to all the documentation and evidence in Croatia. They will also have links there to all the other prosecutors' offices, archives, and we're also thinking about involving NGOs there, because access to the database by the NGO would also enable us in our work to gather additional information in prosecuting perpetrators. The software was produced with the assistance of the Dutch government and was implemented together with our colleagues, prosecutors from Bosnia and Serbia, because the software does not only belong to Croatia. And I think just as we're discussing this, Croatia will be completing the uploading of information into the database on all the perpetrators, suspects, and criminals. And over the next couple of months, we will be contemplating how to enable